Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. One thing that happens when you become a lawyer is it gets really hard to watch a lot of the court sequences in TV and movies because they get things so wrong and it takes you right out of the moment and you're just like, no, it could never happen that way. Now, an exception to this is Better Call Saul, and they do a really good job at a lot of the sequences. It's clear that they've got lawyers on staff who are sort of telling them how things could go. And so it's fairly realistic, and I wanted to have a look at a clip. A lot of people have sent me this one in the past and said, is this something that could actually happen in court? And the answer is kind of yes and no, but let's have a look at Better Call Saul Season 5, Episode 4. And so I'm just going to jump to the clip here.
Yeah, we were hopping because of that Kiss show at the Pavilion.
Now, I'm just going to sort of interject as we go here. This is way more people than I would normally expect to see watching a trial. The usual number of people I've had watching my trials in the past has been 0. But it is open court and people can walk in and out as they wish. And even while you're in the middle of trial, you're expected to do so quietly and respectfully, but it happens. I mean, I've had school groups walk in to watch a trial while I was, in the middle of things, and you just have to keep going and roll with it. So anyway, carrying on here.
Had those leather guys in makeup coming in and buying Slim Jims and beers all night long.
Thank you, Mr. Harkness. Is the person who robbed you present in the court today?
Yes.
And could you point him out to the court, please?
There.
Let the record show that the witness has identified the defendant, Mr. Seki.
Now, this is what we call a doc ID, which means that one of the things that the prosecution or the Crown prosecutor here in Canada, and this is an American trial, but it could happen here in Canada in fairly similar ways. I'll point out some of the differences here. But one of the issues, of course, is identity of the accused in any criminal trial. You have to prove that the person who is charged is the person who actually committed the offense. And so one bit of evidence that they'll often use is this doc identification procedure. Now, a doc identification is not the best evidence of ID because think about it. When you have the witness up on the stand and you ask them to, point out and show the court, who the person was, well, who else are they going to point to other than the guy who's sitting next to defense counsel? Or if you've got a prisoner's box, the guy who's sitting in the prisoner's box. It's not the strongest identification, but it can be at least some evidence towards identity.
Thank you, Mr. Harkness.
Your witness, Mr. Goodman.
Thank you for coming in today, Mr. Harkness. I just want to clarify a few things from your testimony, if that's okay.
Okay.
So,
now, I actually really like this start to the cross-examination because as defense counsel, usually when you're standing up and dealing with a witness, often the witness doesn't much like you. And that's because typically they're there, and especially in this case where the guy is the victim of a crime, he's, you've got a situation where he's not inclined to like the person arguing for the guy he thinks, robbed him. So usually you want to disarm that a little bit and kind of try to establish as much rapport as you can. And you're going to have to kind of gauge that a little bit because sometimes a witness is just going to be seething with hatred for you before you stand up. And in that case, well, there's not going to be a whole lot you can do. But you don't need to come in hot and to attack the witness right at the outset. This kind of thing of saying, listen, I just want to clarify a few things. It's a really good way to sort of introduce and get started that is not aggressive and that can put the witness at ease a little bit.
you were working at the Sandia Mart the night of the 30th, is that correct?
Got in at noon, left at midnight.
That's a long day. Good for you. Nothing wrong with a hard day's work.
Again, you see a little bit of rapport building here. He's trying to be friendly. He's trying to, put the witness at ease. And that is absolutely a good thing to do. You definitely want to do that if you can, at least in most circumstances. when you're cross-examining a witness, you can always get more aggressive later if you have to, but you can't ever dial it back. Once you've been aggressive with a witness, you're not going to be able to recover this kind of friendly conversation kind of thing. So it's always better to start with this if you can.
So you say, a man came in and he reached across the counter and, quote, he grabbed up the money from my register and run off.
Yeah.
Now, you notice that a lot of the questions here are very suggestive. He's telling him what happened and then getting a yes or no to confirm. That's because in cross-examination, you're allowed to lead a witness, and you should lead a witness in cross-examination. You don't want to just give them sort of free rein to go wherever. The other thing here, and, Saul Goodman's got some good cross-examination style, because there's a lot of situations where you need to repeat a witness's quote back to them. And if your witness is somebody who has a sort of a folksy or a different kind of way of speaking, you might need to quote them word for word, but you have to do it in a way where it doesn't come off as mocking or insulting. And I think he does a good job with that there. Just gives him the quote and then gets the yeah. And you can see the witness doesn't appear to be pissed off or put off by it.
And there was no one else in the store.
Not at that time, no.
And since the camera system wasn't working at the time, you're the only one who saw the perpetrator.
Yeah, I guess so.
Now, he already knows the answer to these questions. As defense counsel, usually you want to already know the answer to these questions. And in fact, all he's doing right now, is he's getting these things out on the record, but also putting on a show for the jury, because this is a jury trial. Now, in Canada, this, from the sounds of the little bit we hear of the offense here, this would probably be charged as a theft under 5,000 or maybe a robbery, depending, but it sounds like he just grabs the money from the till, so it would just be a simple theft. And those are basically never heard in front of a jury. So this would be a judge alone trial instead. But there's no reason why you wouldn't ask these questions so far in the same way.
Yeah. So this person came in and they bought something.
I think it was an Almond Joy.
They bought an Almond Joy. And when you rang them up, that's when they snatched the cash from the register. Sounds like it happened pretty fast. But you say you got a good look at them, correct?
Yes.
Now, a judge might intervene there just because some of that was not a question. But, you are allowed a little bit of free form, a little bit of creativity and so forth. And I really like the dynamic between the lawyer and the witness here, because the lawyer's kind of, he's basically trying to find a gap here. And the witness is pretty smug. He's got this, yeah, I've already got your guy dead to rights kind of expression there.
You must drink stronger coffee than I do, because after 11 hours on the job, I can barely see straight. And it was dark out.
Well, he's the only guy that came in that night that wasn't made up like a bat or a cat or whatever the hell those guys are. And he was right up in my face.
Right? And according to your testimony, you feel confident that you can identify this person. That's what you're saying.
So you can see that the witness pushes back a little bit. Even though as lawyers you want to kind of control the witness as you're doing a cross-examination, that doesn't mean that the witness is going to play ball. And so he's telling the jury, oh, well, it was a long shift and so forth. And the witness is going, yeah, but, and catching him a little bit. So that happens, and sometimes it could be devastating to your case if the witness is on the ball. But now we're going to see something that I think is really shows us a bit about cross-examination.
I can. Absolutely. It's him. Your client.
Are you sure that's the person? There's no doubt in your mind. Take your time.
I don't need time. That's him.
Now, would you be surprised?
So here's the thing he's doing. He's getting him to confirm and double down on his story. Because as a defense lawyer, ideally you're in a situation, or as the prosecutor when you're doing a cross-examination, ideally you want to know more than the witness does. And so sometimes you'll have the witness and they've said something that's just wrong. And it might be because they're lying, or it might be because they just have gotten things wrong. Witnesses do that all the time. And you really want to sort of ram that home. And one of the things that you do as an important first step is that you get them to confirm it and really double down on it and really indicate that they are absolutely certain. Because otherwise, when you confront them with the fact that they were, that what they said was wrong, they have all this wiggle room and they can say, oh, well, I wasn't that sure, I guess, and you don't want to leave the possibility that somebody can weasel out of it. So what he's doing here is essentially setting the hook so that now he can then come with the surprising information and sort of stymie the witness.
Surprised to learn, Mr. Harkness, that the person you just pointed to is not the defendant?
What?
And my client is in the back of the courtroom. Mr. Sakey, would you please stand up?
Objection.
Now, the person you ID'd is named Hollis Early. He's a bartender down in Berlin. He has a very good alibi for the night in question.
Your Honor, objection.
Oh, Mr. Goodman, really?
You didn't recognize him either, Your Honor.
All right, settle down, everybody. Settle.
And just briefly for what happens next, she says she wants to see Saul Goodman in chambers. He's in there for some time. Presumably he's getting the chewing out of a lifetime. And then later he comes out and we find out that there's been a mistrial declared. So in actual practice, you couldn't pull this trick, at least not the way they've done it, because this is basically perpetrating a deception on the court, and the court doesn't appreciate that at all. They have to know who's who. And so you can't just bring in another person to sit next to you during the proceeding and pretend that's your client the way he was doing. You saw him sort of reach out and sort of even kind of comfort the guy next to him as if he was the accused. You can't fool the judge like that. Now, there is a variation on this that you can do, and you have to tell the court in advance that you're going to do it. So the judge is in the loop and the prosecutor is going to be in the loop as well. And as part of this variation, you don't actually have the accused sitting next to you. You have the accused back in the gallery, and the gallery presumably full of other people. It's debatable as to the ethics of whether finding a body double akin, in the same fashion here is allowed. I would say probably don't do it. That I would say is probably not ethical, but just having a bunch of other people would be fine. The risk on that one is that, remember what I said about doc IDs not being such a great identification process? Because the guy's being asked who did it and he's pointing to the only obvious choice? Well, if the witness now picks your client out of this crowd of people in the room, now you've just made that identification so much better, because now there were wrong answers that they could possibly have made. So this is not a trick you want to do lightly, which is why it basically never happens. I've never seen anybody do the sort of the ethical or the unethical version of this particular maneuver, but there is a way that it can be done properly. Another thing I'll just note, and this is not a really big deal, but we do see the judge bang a gavel. Now, in Canadian courtrooms, at least where I am, I've never seen a gavel anywhere. So that's another sort of Americanism, but I have won a court case on the basis of that detail. So just a kind of random moment there. Anyway, as I mentioned before, I really do like this episode just for its realism, and this is an ethical problem that lawyers get sort of told about. I learned about this issue in law school, so I very much suspect that the lawyers they've got on staff mentioned, hey, this is a potential, thing that could be done, and which you might see being done by a lawyer who's a little, on the greasy side, which of course is kind of what Saul Goodman is all about. As I said, I don't know any lawyer who's tried this one. I don't know a lawyer who would, but yeah. Anyway, thank you for watching. I hope this has been interesting or educational. I'll probably look at some other clips from the same show, just because there's a whole lot of moments that are just that really ring true and ring with familiarity for me. So I really like the show, and hopefully this commentary has added to it. And if you've not watched the show in the past, maybe you will. Anyway, thank you for watching. I also want to thank my Patreon supporters at the $50 level, Canada's National Farms Association and the CCFR and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited and Marc-Olivier Damour. And at the $20 level, Peter Hilger, Mark, Jane Babin Luxor, Haywire, Dale Nesbitt, Cameron Johnson, Bruno R., Andrew Elsich, and Rick J.D. Thank you as well to the $10 supporters who will be in the crawl immediately following. Thank you for watching, and I hope this has armed you with knowledge.